All right, everybody, on behalf of Trident Title, Performance Title, and Synergy Title, we want to welcome Paul Krasker in for Better Call Paul. Today, we are going to focus on HOA and community disclosures, as well as the Condo Rider for the Florida real estate contract. So I'm going to pull those up on the screen and let Paul go through them. As always, if you have any questions, please send them through in the chat. And when we are done at the end, we will get some Q&A time with Paul and make sure that we cover all that. So Paul, welcome. Thank you. Good to see you as always. How are you today?
Doing well, thank you.
Awesome. Good to see you.
You tell me when you're ready for me to go.
All right. You should be good to go now. I have the Homeowners Association and Community Disclosure up, and I will scroll through and move through as you talk or have any points that you want to hit on. I'll make sure that we see them on the screen.
Okay. So in general, I want to give people an overview of the two documents. Number one,
Paul, can you see the contract on the screen? I just want to make sure you see
yes,
it.
I can.
Okay, perfect.
Yep. So I want to make sure that everybody understands that these are very different documents. One is a disclosure and the other one's a rider, but far from those silly titles, they do very different things. And in general, Florida law treats homeowners associations and condos very differently. And I think it's helpful to look at it from this perspective. I think that the legislature in Tallahassee thinks of condominium owners as little old ladies with white hair sitting in their tall skyrise buildings in Miami Beach. And I think they think of homeowners as working people who live in residential communities that you all know and understand from your own activity. And they feel like they have to protect those little old ladies with substantially more regulation and oversight. And I think they don't feel like they need to protect the homeowners to any great degree. So if you take that oversight with you in reviewing these documents, it helps you understand why there are substantial differences. And the last thing I'll say before I start talking about each document individually is that many times you should be using both. For example, in the land of the presidents that I'm looking at out my office window, there are condominiums, but there's also a master association that governs all of the streets that go from the front gate, that include the front gate, include all the streets and landscaping around those streets between the buildings themselves. So in many times, you both have a homeowners association and a condo association, and you must give both disclosures. But let's talk about the homeowners association disclosure first. As I said up front, and if you look at the bold print in Part A, the only thing the government requires is that you deliver this disclosure. That's it. As long as you fill in the few blanks in items 3 and 6 and get the buyer to sign it and insert the name of the community, you're done. You've done everything that you were required to do under Florida law. And it's up to the buyer, when you look at paragraph 9, it's up to the buyer to obtain copies of all the relevant documents. And literally, the form says, these matters can be obtained from the record office in the county in which the property is located, or get them from the developer. But, that's it. Seller doesn't have any obligation to deliver them. Seller doesn't have any obligation to identify the finances, to do anything other than just get you to sign this document. And if you're representing buyers, that means that you need to go through the association documents before the inspection period is over. And if there's things in the association documents of which that buyer is unaware or can't live with, and it's after the inspection period, you're out of luck. Period. So that's a really big issue. And if somebody's buying it as an investment and they subsequently find out 20 days later after they apply for the association membership and sit down with the board, if they subsequently find out that you're not allowed to lease it for 2 years, or worse yet, you're not allowed to lease it at all in this community, they're going to be really upset with you. And what makes matters worse is a lot of agents don't even hand over the contracts to the title company until after the inspection period is over to start getting the title done. So we don't even pull HOA docs for you until the title comes back. So on the HOA side, there's no protection for the buyer whatsoever. If you're a listing agent, great news, just fill out the form properly, and that's the end of it. And if you're a buyer, representing a buyer, then you have to do a lot more due diligence. You want to get the documents as quickly as possible, send it to the client, email it, send a link in an email, whatever you want to do, but make sure they have it before the end of the inspection period, and let them know you only have the inspection period to review these and to consent to them. Okay, couple of other things on page 2 of the part B, which is page 2. You certainly have to fill out the payment of fees, assessments, and other charges and number 2. And you have to check the box in 2B whether buyer or seller are going to pay any installments of any special assessments post-closing. Obviously, most buyers who are submitting an offer and filling this form out check the seller box. But most buyers don't have all the information to be able to fill out the form properly, and that's usually when you turn back to the seller and say, have you filled this out, or look on MLS and see if it's already filled out for you so that you can fill out the information and send it back in. Last piece that I wanted to talk about is this approval process at the top of page 2, paragraph 1 of part B. So this gives the buyer an out if they're not approved within a certain time period. If you look on line 3, it says, or line 2 at the end, it says within blank, and if left blank 5 days after the effective date, the seller shall initiate the approval process with the association. Okay? That always throws people because most people think the buyer's responsible to do everything. Usually there's a form that the seller has to fill out that says, hey, I'm selling my unit. Here's a copy of the contract, and please send any approval documentation or applications to the buyer at this email address. And that's all you're really trying to do to get this started. But sellers, make sure you do that within the 5-day period. And then oddly enough, it doesn't say that the buyer has to do anything within a specific time period at all. All it says is towards the end, third line from the bottom of paragraph 1, sign anything, deliver everything, and say use diligent effort to timely obtain approval. So when I have sellers who say, I don't think that the buyer met their time deadlines because they didn't apply within 5 days, and I want to keep their deposit, even though they're trying to cancel on the 10th day of the inspection period, I turn back to them and say, well, there was no 5-day obligation for the buyer. There was a 5-day obligation for you. Did you submit what you needed to within that 5 days? and then we have to contact the association to see if the buyer did or did not cooperate when they submitted their application. But please know from that language that there's no specific contractual timeline in which they're supposed to get this done. They just have to use diligent effort to timely obtain. And again, it says if buyer doesn't get the approval 5 days prior to closing, then they can terminate and get their deposit back. My last comment on this document is that first blank that says that you need to get the approvals 5 days prior to closing. If you're representing the buyer and you put it, I want it 10 days before closing, and if they don't have it, they get to walk, that's not really fun for the seller to take that risk. The seller probably wants it 2 days before closing. Give them extra time, just make sure that it's done prior to closing. But a lot of people misread that paragraph, so I wanted to touch on that as well. Does anybody have any questions about the HOA disclosure prior to me jumping to the Condo Rider?
Guys, I'll open that up. Anybody, any questions? You can either type them in the chat or you can unmute yourself and jump on. And if not, then we'll move on, but I'll give it a minute for questions here.
Paul,
Oh, go ahead.
sorry,
Yes, Sherry.
it's Sherry. Hey, if there's nothing for the seller to do though, you know how some HOAs don't have a form the seller signs to say I listed my house for sale, then there's still no burden on the buyer to meet a deadline?
So if there's no form that they're asking the seller to fill out, I'd still like you as the listing agent to send an email to the management company that says that we have a contract to sell this property, attached is a copy of the fully executed agreement, and here's the contact information for the buyer. That way you're dumping it in the buyer's lap, and I would even copy the buyer directly on that email so that you know that they know that the association management has the information and that that buyer now has the contact information for the management company. And you may also want to add to that email the management contact information to say, and by copy of this email to the buyer, I'm also giving them the management company contact person and telephone number. That way you've really done everything you could do to make sure that this gets timely done.
Great.
Okay, thank you.
One other one that's in the chat, Paul. How do we know if there is both HOA and condo or just one or the other?
Well, if you're farming a specific area, you should ask the management companies to know what it is. Ideally you want to put a form Condo Rider and a form HOA Rider within as attachments to your listing agreement, so that people have the right numbers, and when a buyer is submitting an offer, they attach the correct form with the correct information. So yeah, you want to do some investigation, call the management company as you're taking the listing and find out that information. Is there a master association in addition to, the condominium?
Also, one other question on that, Paul. On ones that have like two homeowners associations where there's like a village or a small piece within a big one, is there two disclosures required or just one with a slash showing both documents? Or
Yeah, I do it on one document and I do a slash and I say, PGA National Homeowners Association / Prestwick
village or
sub-association.
Yeah.
And then I put on the back page, on page 2 and B, I'll break out both. Yeah.
Got it. Another one, is it possible to add a sentence on the additional terms of the contract to obligate the seller to apply to the HOA within X number of days?
You mean obligate the buyer to apply?
Probably what they meant, yeah.
Yeah. So yes, you can do that, and then it becomes a contractual obligation. If they don't meet it, they breached it. And same thing with buyers ordering appraisals. You don't want to give them 15 days to start ordering an appraisal until after the underwriting desktop and the inspection periods are over, because then you're bumping up against the closing date.
Yeah. And one other one, if you represent the buyer, you don't always get the phone number for the HOA. Is there another easy way to look it up? Sunbiz, or I will answer. There's also a tool in the MLS that you can look it up that helps. And Paul, any other ways that you know?
No, just asking the listing agent for the information.
Yep, makes sense. Okay, I'm going to go on to the condo doc here. Let me share that screen 1 second. All right, Condo Rider, I got it up. Take it away.
Okay, so just as my introduction stated, the condominium rider is a much more significant document, provides substantially more protections to the buyer, and is much more difficult for a listing agent to fill out. I encourage you, as we're just mentioning with the HOAs, to reach out to the management company when you're taking the listing. Have a conversation with the person who is responsible for this condominium to know what these obligations are. The first section is talking about, does the association have an obligation to approve the buyer? Yes, no. And then the second section is talking about, is there a right of first refusal for the association? A is the association. B is the member of the association. I have an 8-unit condominium association in Palm Beach, and 2 of the unit owners are fighting with each other about who gets to buy units. And every time a unit comes up, one of the 2 of them want it, and they fight about who gets to buy this one. So you need to be aware of those issues. You need to ask the management company so that you can fill out this form correctly. But let's go back up to paragraph 1. Same language as you saw on page 2 of the HOA rider. It creates an obligation for the seller to initiate the approval process within 5 days of the effective date. And then if you leave it blank, it also creates an out for the buyer if they don't get condo approval within 5 days prior to closing. There are some associations now that are taking longer than the closing date to get back these background checks, etc. I don't think it's as prevalent now, but it certainly was a month ago. And so you really want to be on top of that. So I'm going to go down. Let's see. I'm going to go down, I think paragraph 3 is self-explanatory. And cover paragraph 3C. Yep, top of page 2, middle of page 2. Lots of agents get stumped on this, and it can be frustrating. Again, really important to have conversations with the management company up front. Some of the management companies charge for this information. Others already have it in a drop link box that you can just send the link on to all prospective purchasers. But here's what the language says. It says that seller represents that they're not aware of any special or other assessment that has been levied by the association or that has been an item on the agenda or reported in the minutes of the association within 12 months prior to the effective date. And those are considered pending special assessments, okay? If you don't disclose something on there and they were effective as of the effective date, then the buyer has the ability to check the box for seller, and the seller has to pay it in full. So if you're representing a buyer, you check the seller box there and force the seller to tell you what's going on with the association. Because if they leave nothing in there, leave it blank, I promise you, and this is a promise, a real promise, There is not a 12-month period of time in any association that I've ever seen where somebody hasn't brought up an item for the agenda or stated something on the record that ended up in the minutes that said, we should have a special assessment for X. They always talk about it. Somebody wants to redo the lobby. The elevators don't look nice anymore. We need to do the interior of the elevators. The pool deck's horrible. We need new landscaping. Why don't we do a special assessment? There's always a mention of that, and it's going to come back to bite you if it happened within the prior 12 months and you don't report it. Okay. Then a lot of other agents ask me about paragraph 3C3. If special assessments are levied or pending, exist at the effective date, and haven't been disclosed above, then it's automatically the seller. So again, 3C1, the seller has the ability to put the information in there. If they don't put information in there, it automatically goes to 3C3, which says, hey, you didn't disclose it, you're paying it in full at time of closing. Subparagraph 2 says that you can choose. Now, if I'm representing a buyer and I'm filling out this form, I'm always going to check seller. So whether they disclose it or not, they're paying for it. But some sellers say, hey, I told you they're doing a special assessment for the pool deck. It's going to be done next summer. It's going to be solely for your benefit. You're paying those special assessments that are due after closing. Here's the interesting one, and I get a lot of questions on this from buyers of what happens on 3C5. Oh, I'm sorry, 3C4. On 3C4, if it happens after the effective date, then the seller pays all amounts due before the closing date and the buyer pays all amounts due after the closing date. So if there's been talk about it, if it's a pending special assessment and it's been disclosed in C1, then the parties have the ability to negotiate in C2 as who's going to pay. If it wasn't disclosed, then the seller's going to pay it in full. If it was not disclosed but comes up after the effective date, then it's presumed that the major benefit is going in the future to the buyer. So the seller's just going to pay any expenses that come up before the closing date, which are likely none if it was just approved. But they'll pay, the first installment of whatever it is prior to closing. Now, I have had some times, and these are usually big numbers that people are fighting over, where the association gives people a choice. They can either make one payment of $40,000 or they could make 10 payments of $4,000. Now, obviously, the buyer in that circumstance is going to argue that there's one payment due of $40,000 before closing, so the seller should make the whole thing. But I think logic would say that the seller's in charge of how they're going to pay it. They're going to say that it's over 10 months at $4,000, and I'll pay $4,000 and you pay the rest. All right. Litigation, seller's not aware of any pending or anticipated litigation. This is a tough call because you've got to tell people if there's pending litigation outstanding, period. You've got to tell them, and you can't just close your eyes. If you were mailed a quarterly update or a email of an existing litigation and they find out you knew about it, you didn't tell them, whatever your liability is associated with that litigation, they're coming back at you for it. Okay. Now I want to jump down to paragraph 5. I'm really surprised how many listing agents aren't in a position to check box 5A. This is a fight all the time. Nancy can tell you we deal with this at least once a year, where some buyer comes 2 days before closing and says, I never got the frequently asked questions and answer document, I'm terminating. And the seller has to give up their deposit, hand it back over to the buyer, and start all over again. There's no reason why you don't get from the management company all of these documents. And there are a lot of documents. The declaration, the articles, the bylaws, the rules and regulations, the most recent year-end financial information. So for us, that would be 2019 financial information, and the frequently asked questions and answer document. You have to give all of those, and any updates that there have been. You can't just take the 1972 version that were in the drawer at the condominium from 3 owners ago and hand it to the next person. You've got to see if there were any amendments, any updates of record, and you've got to hand those over. It might cost $250 from the management company, but it's well worth the seller's money to do it and get it into a scanned format, whether it's a link or a Dropbox or just attaching the documents to multiple emails. But send those over or attach them to the MLS listing as attachments so that you could check box 5A and let their 3 days run out during the inspection period. You don't want it to extend beyond the inspection period. You don't want to give them a right to terminate 2 days before closing. And if the seller's really not able to do that, then you have to check box 5B and pursue those documents as quickly as possible so that you can end their right to terminate under the disclosure. So Ryan, if you switch to the top of the next page. If you're representing a buyer, the statute actually says that the buyer has to request the documents. So paragraph 6 is where you request them. So if they've checked box 5B that says we'll give them to, it's voidable to buyer. Well, if you go scroll up a little bit, Ryan, it's right there. Perfect. The second to last line in the all caps says if requested in writing. And so 6 gives you the ability to request it in writing. So you want to, if you're representing a buyer, you want to check the box requests. And if you're representing a buyer and you check the box does not request, then you can't terminate based on that information because you've given up that right and you just lose if you challenge. Okay, if you jump down to 7, good. If the buyer has received the documents already, then you want to put in the date you gave it to them. If you're the listing agent and you sent the link 2 days earlier, right when they went for their first showing, put that date in there. If it's the day of sending the contract, then put that date in there. Okay, getting down to the nitty-gritty on the back of this thing, the common elements. I've had so many fights with people about parking spaces, garage numbered spaces, and storage units. Other is what I usually put in the storage unit. If there's a specific parking space and it's listed in the MLS listing, put it in here. What you don't want to find out is they said they had the best space in the place. It was right next to the entry door. It was covered. And then when you go post-closing to your meeting with the management company, they send you 12 blocks that way and 3 blocks down the street, and put you next to a fire hydrant with a tree that's got birds' nests in it right above you. And they do that all the time if it's not assigned parking. So you want to make sure you have it. So I think that's it. I'll open it up to any questions, but this is a substantially more detailed form. There's more required of both the buyer and the seller, and it's easy for people to get out of this contract if you don't pay attention to the condo rider.
Couple questions on here, Paul. One, doesn't this addendum just ask what the seller is aware of, not necessarily what is actually true, sort of like a seller's disclosure?
That's certainly true. And if you're a seller who's not aware of anything, we're not asking you to create things. By the same token, if the association has been mailing you letters and you just throw them in the garbage, I think you've got a tough argument to say that you shouldn't have known about that when the disclosure was there, or the association comes back and says, well, we sent you an email on, October 14th of last year that addressed this very issue. It's tough to say that you didn't know, and it opens you up to liability. So my best advice, if you're representing a seller and you call the management company, is for the listing agent to say, are you aware of any special assessments? Are you aware of any changes to the assessment amounts that we've received from the seller? The seller told me it's this, this, and this. Are you sure that this is accurate? Are there any pending special assessments that you're discussing at the board level, either in the minutes or the agendas? And can I have a copy of the last 12 so that I can send it on to the buyers? Those are the kind of things that you want to do so that nobody has that lawsuit to bring against you
Makes sense.
6 months down the line.
Makes sense. All right, it's very similar questions here, two of them. Is it legally acceptable to modify this standard form and add to either Section 5A, or the other question was to Section 7, basically saying that the documents are available inside the MLS listing or that they're available somewhere?
Well, you can, I don't know that you have to modify it. If you put them in the MLS listing, if it were me, I wouldn't modify the document. I would just put them in a link in an email, or reference the MLS listing and put that in a link and send it to the buyer's agent and say, please confirm you're in receipt of this email. The condominium documents are attached to the MLS listing, which is attached here too. Please confirm receipt of the same. And the other listing, or the other cooperating agent's going to have to respond back. And if they don't, you just send them an email every hour until they do.
Makes sense. And then that's timestamp that's covered.
Yep.
And then another one, should we request meeting minutes for the past 12 months?
Yes, and agendas.
And agendas. Okay, great. Sherry says she has a question about the sprinkler retrofit. Sherry, are you on here still?
Yes. Hi, Paul. Hey,
Hey,
I know
Sherry.
we didn't touch on that paragraph, but I recently heard that by the year 2023, all condo buildings over 7 stories high have to do a sprinkler retrofit unless they hire like a fire marshal consultant to prove that their building is accessible a different way. And I think it's because the fire truck ladders only go 7 stories high.
Yeah, but there's also some ability to forego the retrofitting if there's an affirmative vote by a certain percentage of the condominium. I don't know what the certain percentage is, but if you get into that scenario, then I can certainly help you with it. It's most of the associations who have buildings that were many years prior, it's just too darn expensive for them to go ahead and do the retrofit. So they all go the route of getting a fire marshal to turn around and say, no, we can get into the stairways on the 5th floor and we have access to the, emergency hallways from there, and there are 2 or more emergency hallways, so we're fine. And then they still need the vote of the association to opt out. But there is an opt-out process that doesn't require everybody to do it.
I only mention it because that would be a major special assessment, and if they talk about it at meeting minutes, then, you know.
Sure. Yep.
Makes sense. Anybody else, any questions on HOA or condo? All right, Paul, I have 2 questions that are not related then that came up, so I want to get both of those answered if you don't mind. One of them, can a married woman buy an investment property by herself, and then if she dies, who gets the property? She wants her kids to get the property, not her husband.
Okay. When you say investment property, I assume you mean residential property for investment purposes?
I think
Correct.
yes.
Correct.
Okay. This is a tough call, and let me tell you why it becomes a tough call. Most mortgage companies and mortgage brokers want you to apply like it's a second home so they can get you a lower rate. And if you turn back and say it's a second home and that you're going to use this as a residence, yes, the woman can buy it in her name alone, but the husband is going to have to join on the mortgage to waive his potential homestead rights.
Okay.
Or sign some sort of affidavit of waiver of homestead rights.
Well, if the husband currently has homestead rights on a home.
Right. So let me tell you what happens in divorce situations. The husband goes to an attorney, and the attorney is a pit bull, and the pit bull says, there's more equity in that property over there. Tomorrow I want you to go change your homestead status to that property over there.
Okay.
And so title companies always get screamed at by buyers and realtors because we're not able to insure a property unless we get the husband's signature. Now, I had a situation earlier this year where there was a guy from Arizona who was married in Arizona, and he was hanging out in Florida with his girlfriend, and he wanted to buy a property in South Florida, and they asked us to insure the property, and the mortgage broker was trying to get him the lower rate and not have it be an investment property, and got him a second home rate. And I said, well, if it's a residence, I need your wife to sign to waive her homestead rights. And he said, don't talk to my wife or I'll sue you. Which is always nice to hear from somebody. And so you know that if that's how this guy feels today, that something's going to go on in the near future, and there is going to be a challenge, and whoever that pit bull that the wife hires is going to figure out that there's a $400,000 home that's unencumbered in South Florida that he calls us a second home, and she's very well might likely turn around and say, oh, thanks for buying me that second home, and file a homestead the next day.
Okay. So even if it's a true investment where she were to put the 20% down or 25, whatever she needs to,
Yep. If the loan is booked as an investment property, then the husband doesn't need to sign.
okay.
Then I can get an affidavit from the wife that says, I'm buying this for an investment. This is not personal residence, and homestead cannot be my homestead property or my spouse's homestead property. This is investment. Then I can go forward and insure that property. Yes.
Okay. Thank you.
Yep. And you can even do a life estate deed so that it's in her name, and automatically upon her death, it transfers to the kids.
Okay.
So you wouldn't even need to rely on a will or anything of that nature. You wouldn't have to go through probate. It's a great way to take it if that's her intention.
Yes. Okay. Thank you.
Sure.
All right, Paul, two more non-related to HOA, and then we'll let you go. One, if I create a will document, where does the document need to be registered to be valid and enforceable? I assume there's a requirement for witnesses and notarized signatures. You could answer that one quick because we're going to talk about wills and trusts and everything the next one.
Sure. So a will is not registered anywhere until you pass. It's usually kept in your lawyer's office in a will safe. Mine burns at 5,000 degrees Fahrenheit for 5 hours before I'm told anything's damaged. I've never tested that theory, but and it also keeps the will out of the hands of somebody who might not like what they find and rip it up. So wills are usually kept in a lawyer's office. Lawyers are required to deliver the will to the probate court within 14 days of notice of the person's passing. So there's no registration requirement, but if you're looking to do transfers to other family members of real property, you shouldn't rely on a will. You should either draft a revocable trust where you're the trustee and you appoint a successor trustee upon your passing, and you appoint successor beneficiaries upon your passing as well. That's one way to transfer things effectively without having to go through probate. And then the other way to do it is what I mentioned a minute ago, which is the life estate, which allows you to own and control the property during your lifetime, but upon your passing, it automatically transfers to, say, your children.
Awesome. All right, one more. Short sale approval contingency rider for the king of short sales. The default for short sale approval deadline is 90 days on the form. If the client or the agent's buyer puts in an offer, is he locked in for those 90 days? Can he or she put offers on other properties? If during that 90 days he finds something else that he likes better, can he just cancel? If not, do they need to put the offer that it's good for only a certain period of time, such as 15 or 30 days?
Yeah. So you want to give the short sale negotiator adequate time to get a short sale done. I tell people we need 120 days. There are times we can get it done in 90. There are times we get it done in 60. But you want to set realistic expectations up front. And if somebody's really in that much of a hurry, they shouldn't be buying short sales. They should be buying something else. So I prefer to put 120 instead of 90. The other piece of that, the question really surrounds one of the other boxes that you have the ability to check in the short sale rider. The short sale rider says that all time periods under the contract start, and then there's a box that you can check that says upon notice of approval of the short sale by the lender, or at the time of execution of this agreement. So the person who's asking that question, they want to give somebody 120 days, but they want to check the box that says that the other time periods don't run until after the short sale approval. So what they could do is, if they want to keep looking for other properties, but they want to put this under contract, give them the 120 days or give them the 90 days, knowing that it's an as-is contract. And on the 120th day, if you get a notice that they did get short sale approval from the existing lender, then you go do your inspections and you terminate under the inspection period. You had 10 days to do an inspection, 7 days to do an inspection. You walked away because of that.
Makes sense. Awesome. Paul, as always, thank you. And everybody on the call, we appreciate you. As you guys know, this is brought to you by Trident Title, Performance Title, and Synergy Title. If you do have any deals coming and you have been sending them, we've had a great couple weeks here, so we really appreciate that. If you have not yet sent us a deal for whatever reason, we appreciate you and we know that they're coming, so thank you. Thank you to Gabrielle Bryce, Melissa Kidwell, Dave Ward, Tracy Cinder, all on the call. If you guys need anything from us, let us know. And if there are any new topics that you want to see, let us know. We have topics planned out through June. We have a live question and answer coming up next week, and then a will and trust whole class coming up 2 weeks from today. And also, if you are looking to take more listings, make sure you are on our call Monday at 11 o'clock. It is for everybody, 29 different strategies to get new listings. So thank you,
Ryan, we're always looking for new topics too. So if anybody has ideas of something they want us to research, we're happy to research it and put something on the agenda for July.
Awesome. Yeah, that would be great, guys. Text me, message me, Facebook me, whatever you want, topics, and we will get them out there for you guys. So thank you all very much. Please keep
Thanks,
sending in the
Paul.
title deals. We appreciate you. And Paul, thank you as always.
See you
Thank
guys.
you, Paul. Thank you, Ryan.
Bye, guys.